Thank you.
You're welcome.
All of a sudden, they're looking at each other.
Is it going?
It's recording now.
Yeah. It's good.
If you hit the basic one on the mouse,
Okay, I'll just say I'll start with because I was looking to the end of a business meeting.
Yeah.
good.
Yeah.
I never did know.
That's sweet, dude.
No, I
All right, so
He's kind of for it. I was surprised. And even Ron Sequel was something he was, I don't know.
But it's so confusing too because our degrees are all
Okay. And what's that?
that's a bachelor's of law.
Oh, okay. All right.
They've changed it now to jury stuff.
Oh, okay.
Makes it a little easier for you.
He was actually quite comical because they felt like some dumb that nobody can answer.
That's good.
Yes. Thank God for Google.
Yeah. I don't know what we did in the days before.
Yeah, I don't know.
Walked around cool.
Hey, you walked around and asked people,
Yeah.
what's this mean? Good, and yourself?
That's why I do so much municipal work, but a lot of it's very remote, so I don't know if it's Oh yeah, so they'll come to you about 10 o'clock tonight.
Yeah, that's right. Okay, well,
Alright, they're closing the doors, let's go.
we'll go for it. Good afternoon. I guess we're going to start the session here. I'll give you a minute or so to get organized. And oh, it didn't even take a minute. You guys are quick. Welcome, delegates, to this session on privacy legislation and council. My name is Barry Rudd. I'm the mayor of Maple Creek and director of SUMA for Southwest Saskatchewan, the Southwest region. We'd like to remind you to check page 41 of the handbook for a note to the emergency exits. This session is also being audio recorded, and people asking questions need to speak clearly into the microphone. That's very important. And I'm supposed to remind you that the last bus does leave here at 5:30. The busing, as you know, this year has changed a bit with First Bus. So the last bus is leaving here at 5:30. Otherwise, you'll be hitchhiking or taking a taxi. The video sessions, they're audio recorded, and recorded presentations will be available on the SUMA website the week of February 17th. Again, just so you guys know. Okay, this session, an outline on this session is privacy and legislation and council. Information is often released on a need-to-know basis, but who needs to know is always the question. Council regularly handle information that could be considered private, and they must make decisions about how and when to allow that information to become public. This session will walk you through some of the privacy legislation that applies to municipal governments and how to avoid inadvertently breaching privacy laws. Our facilitator today for this session is Candice Grant. Candice is a practicing lawyer at Robertson Stromberg in Saskatoon, focusing on civil litigation. She has experience in commercial disputes, municipal law, employment law, and education law. Before studying law at the University of Saskatchewan, Candice's studies focused on criminology. She received a Bachelor of Arts with great distinction in 2005 and a Bachelor of Law with distinction in 2008, and she was called to the bar in 2009. Candice is a member of both the Canadian Bar Association and the Saskatoon Bar Association. She enjoys the opportunity to learn new areas of the law and develop expertise in how best to provide practical solutions for her clients. Candice contributes to the number of well-known community institutions. She has been a board member of the Child Hunger and Education Program for 5 years and currently sits as chair of that organization. Candace also serves as a member of the Saskatoon Public Library Board. Please welcome Candace Grant.
Thank you, Barry, and welcome everyone. It's great to see a second full house here today. I didn't know that anyone would actually think privacy law was interesting enough to come to my session, so I'm very pleased to see you all here today. So as Barry mentioned, I'm a lawyer in Saskatoon with the firm Robertson Stromberg. I do a lot of municipal work, and one of the areas that we're seeing increasingly having questions and concerns about is privacy law. So I do hope you get something interesting or valuable out of today's presentation. It is a little dry just by nature of the content, so please bear with me. We do expect to have some time for questions at the end of the session. Because of the nature of the recording, I'll just ask you to keep your questions for the end and then to make sure to step up to the mic so that they can be recorded for the sessions that will be available for you later on. So we'll start out with just a brief introduction and an overview of today's session. There are actually 5 pieces of privacy law that can potentially apply to you in Saskatchewan. So we'll go through these briefly and then I'll tell you what we're actually going to focus on today. The first is the Freedom of Information and Protection of Privacy Act. Now, this is a provincial legislation and it applies primarily to the Saskatchewan government and to Saskatchewan government institutions. So typically, unless you are dealing with a department or a ministry, you are not going to have a lot of involvement under this act, but just something to be aware of. And a lot of the principles under that act are the same as the principles under the Local Authority Freedom of Information Act, and that's the one that we've got to be really worried about. So potentially something to be aware of, but not really all that much. The second piece is the Health Information and Protection of Privacy Act. So this again is a provincial act. It deals exclusively with health information. So will not normally apply to municipalities in the normal course unless you're doing some health outreach type work, gathering health information, potentially with respect to health information of your employees if there's a need for you to collect that information. The next is the Privacy Act of Canada. This is a federal act. It applies primarily to the Government of Canada and federal government institutions. So again, unless you're corresponding or having dealings with a federal government institution, it's not too likely that you're going to be dealing with that act. And the final is the Personal Information Protection and Electronic Documents Act. Try saying that one 5 times fast. That one, you may have heard referred to it before as PIPEDA, and that applies to federally regulated organizations, First Nations, railroads, that sort of thing, and also to private enterprises when they're dealing with customer information. So really not a lot of concern for municipalities under that act. What we are concerned with, though, is the Local Authority Freedom of Information and Protection of Privacy Act. So this is a provincial statute enacted in 1990-91, and this is where most of your duties and obligations as a municipality are going to arise out of. For today's purposes, I will call it either the Act or LAFOIP, which isn't the most beautiful sounding short form, but it's what we're stuck with, and it's a good way to distinguish it from some of the other acts that we talked about on the last slide. So under LAFOIP, there are 2 major focuses, and these focuses are the protection of privacy and freedom of information. Now, at first, these 2 seem like they're a little bit in opposition to each other. On one hand, you're trying to protect confidential information, and on the other hand, you're ensuring that the public has access to information. So one of the main focuses of the Act is how to reconcile those 2 conflicting concepts and how to deal with requests for information and how to maintain confidentiality of information where confidentiality is required. So we're going to talk about both of these areas in a fair bit of detail. The first, protection of privacy, deals mainly with the collection, use, and disclosure of personal information. And you'll hear me use those 3 words a lot, collection, use, and disclosure. And the Act talks about each of those aspects of personal information separately. And so on the freedom of information side, what we're talking about is public access to information and transparency at the local authority level. So before we get into those 2 major focuses, just talk a little bit about the basic premises of LAFOIP. So the Act applies to all Saskatchewan municipalities. There's no exceptions, no exemptions. You're basically all caught by this Act. It also applies to all records. So under the Act, a record is a record of information in any form, and it includes information that is written, photographed, recorded, or stored in any manner. Now this is very broad. It includes your emails, correspondence, photographs, reports, handwritten notes. Basically, the rule that I've told some of my clients is if it can be filed, it's a record. If you have a way to store it, it's a record. It does not include computer programs or other mechanisms to produce records. So if you've got some specialized software, that software itself is not a record. Now, it applies to all records which are in the possession or under the control of the local authority. And so the Privacy Commissioner, which is the provincial body that oversees this legislation, has told us that possession and control are two different things. So possession relates to the physical custody of the document. In other words, is the document physically located within your municipal offices? In that case, you have possession of the document. You may also have control over documents, and that means that you have the authority to request the document. So one place where this might come up would be documents that are in the possession of a third party. If there's a contractor that you've engaged to perform functions for the municipality, they may have records in their possession that you would be able to request and that they would be obligated to give you. So that would mean that they are in the control of the municipality. Another interesting place where this has come up relates to, for instance, personal emails of council members. If the emails are being sent from a municipal account, it's very likely they are in the control of the municipality because they do have the ability to access that material. So moving then into the first part of the Act, which is the protection of privacy. This is set out at Part 4 of the Act, and it applies to all personal information. So personal information includes a whole list of items that you'll see there. Basically anything that is identifiable about an individual. So individual characteristics like race, sex, family status, marital status, sexual orientation, all of those sorts of what I call the human rights issues. Those are sort of the first major category. In addition, anything that relates to the education, criminal, or employment history of the individual, health information, identifying numbers, for instance, an employee number, or password, home and business address, telephone number. And this next one's a little bit interesting. It's the personal views of the individual, except where they are about another individual, and the personal views of another person about the individual. So, if you've learned nothing else yet, you can learn that LAFOIP is a little bit tricky, and when you're faced with issues under it, you're going to have some concerns because none of it is all that straightforward. If you look at that wording, you're going to have some questions about whether any particular record falls within that definition or not, and so it can be a little difficult to sort things out. But the example I gave earlier, if you're on your council email and you send an email to your mom about how you feel about the latest fashion craze, that's personal information, right? That has nothing to do with your municipal functions. It is only your personal views, and it is not about another individual. So you've worked through the analysis, you've got there, that's personal information, and it wouldn't be disclosed in proceedings under the Act. But if you send an email to your mother about how you dislike another council member, now you're in trouble. And that information potentially can be disclosed if there's a freedom of information request that is that sort of second aspect to the Act that we'll talk about in a little while. So some other areas of personal information: correspondence that's sent to the local authority in confidence, tax information, financial information, and in some cases, the name of the individual. Now, the name of the individual in particular is a tricky one, and that's why I put in some cases. There's no clear-cut answer here, and I'll talk about one of the major concerns with this a little bit later on, but as a general rule, you have to be very, very careful disclosing the name of an individual in any circumstance. So just something to be aware of. If you are looking at whether that's something you can disclose, make sure you're taking into account all of the Act and everything that we're going to talk about today, because it can get you into some trouble. Now, the other thing to note here, this list is not exhaustive. This is information that is included in the definition of personal information. And you'll see throughout the Act, if you take the time to flip through it, whenever they're saying it includes information, they mean there could be other things that would fall under that. So one of the examples of information that would be personal information that's not on this list would be a photograph of someone. Their likeness is considered to be their personal information, even though it doesn't fall under any of those enumerated categories. So the basic premise of this portion of the Act on the personal information side is that personal information is always confidential unless an exemption applies. So there are several exemptions to what constitutes personal information. For instance, the classification, salary, benefits, and employment responsibilities of an employee or officer or a former employee or officer. Another, personal views given by an employee in the course of employment. So going back to that issue of talking about other council members in your emails, that's considered to be in the course of employment, or in this case, the course of the position. Details of a contract with the local authority, including financial details. And finally, expenses incurred by an employee while traveling on the local authority's behalf. So anyone who's getting their expenses covered here today, that's not personal information. The purpose of these exemptions mainly seems to be to ensure that there's transparency by the local authority, that you can't hide behind saying something's personal information and make sure that the public isn't aware of things that they should be aware of, like financial benefits that are offered to an employee or to a council member. So as I mentioned before, there's three main areas that are regulated under LAFOIP when it comes to personal information. And the first is the collection of that information. This is set out at section 24 of LAFOIP, and it basically provides that personal information should not be collected unless it's required for a program or activity of the municipality. And that program or activity can be an existing program or activity, or it can be a future program or activity, but there has to be some nemesis between the information that's collected and the functions of the municipality. So this is certainly not to say you can never collect personal information. In some circumstances, you're required to, right? You need personal information about your employees, so you can contact them, so you can make proper payroll deductions. You need information about your ratepayers, so you can assess taxes. There's all kinds of personal information that you're going to need. But the key here is that you need to collect it only when it's required for a purpose. And when you do so, you have to make sure that you're collecting it whenever possible directly from the source. So for instance, if you're getting your employees' payroll information, you should get your employees personally to fill that out, not their spouse, not an administrator. It should always be coming directly from the source. The individual should be informed of the reason for collection so that there's transparency from the municipality. And you have a duty to ensure that your records are as accurate and complete as reasonably possible. No one's holding anyone to a standard of perfection here. It's a reasonable standard. So making sure that you've got safeguards in place to make sure that your information is correct. As we'll talk about later, there's a right of correction for an individual, so making sure that those are complied with properly. And just making sure that you're checking that information periodically to make sure it's up to date, complete, and accurate. So the second aspect of personal information is use. Basically, under this section, personal information should not be used without consent, except in very limited circumstances. So again, the general requirement under this portion of the Act is that you don't use the personal information unless an exemption applies. Similar to collecting it, similar to disclosing it, the presumption is that you're going to keep that confidential. So use means internal use by the municipality. This is when you're collecting information and making internal use of it. It can always be used for the purpose for which it was collected. So when you're making those payroll forms, you can use those to carry out payroll deductions. When you're gathering tax information, you can use that to collect your taxes. There's an implied consent by the individual once they've given you that information that you can use it for the purpose that you've told them you're going to use it for. To use it for any other purpose, you either need express consent from the individual or you need to fall under one of these exemptions. So first is compliance with a court order, rule of law, or in a lawful investigation. So I don't know if anyone's been involved in any litigation, but if you have, you might know there's typically a duty to disclose any documents that are relevant to the matters in issue in the lawsuit. And so in that case, you might have to disclose personal information to the other party in the lawsuit to comply with the rules of court, and that would be justified under the Act. You can also use personal information to obtain legal advice for the municipality. In some cases for statistical purposes. So this one's kind of funny. Typically, if you're giving out information for statistical purposes, you're going to give out an aggregate or a summary, right? Say 43% of our taxpayers are between the ages of 37 and 53, or whatever information you're giving out. It's not going to be about an identifiable individual. So this particular exemption relates to information which is about an identifiable individual. So to invoke this exception, you need to show that the person actually requires it in a non-aggregate form to do their research, and you need them to sign an undertaking that they're not going to disclose it for any reason. So I actually can't think of any examples where that's going to apply, but should the occasion arise, it is there. And then finally, there's sort of a catch-all on the use of personal information. So to protect the health and safety of any person, that might be the person you're making the disclosure about or any other person, and also in compassionate circumstances to notify next of kin, and that can be in cases of accident, illness, or death. And just a couple other exemptions on the duty to keep personal information private. First, if the information is already publicly available, it can be disclosed. So if you've got a telephone directory that has the number in it, there's nothing restricting the municipality from giving out that information. One of the bigger places where we're seeing this, it relates to ownership of land. If someone is the registered owner and that's evident from ISC, it's not personal information anymore because it's publicly available, and you as a municipality can disclose that information. And finally, personal information can be used if the public interest in the disclosure outweighs any invasion of privacy, or the disclosure would clearly benefit the individual to whom it relates. So an example of this, as I mentioned before, likeness of someone, their photograph, is personal information. So if a municipal employee goes missing and the municipality has the most up-to-date photograph of that person, they would be justified in using that, in disclosing it to a third-party police investigation, media, whatever it might be, because the public interest in finding that missing person outweighs the invasion of privacy, and the person who's gone missing would clearly benefit from being found. So the final aspect of personal information is disclosure. Disclosure means providing that information to an individual or entity outside of the municipality. Personal information cannot be disclosed without consent unless there's a specific exemption. So you're probably seeing a bit of a theme running through here by now. When it relates to personal information, your duty is to keep it confidential unless there's something specific under the Act that says you can disclose it or use it or collect it. Disclosure exemptions are pretty much the same as those for use. So just like we saw in the last couple of slides, compliance with the law, getting legal advice, statistics, health and safety, those sorts of things. Those will justify you in disclosing personal information that you would otherwise be obligated to keep confidential. In addition, personal information can be disclosed to the Privacy Commissioner. So this is typically a requirement if a Freedom of Information issue gets all the way up to the Privacy Commissioner's review stage. The Commissioner will almost always want to see a copy of the record in question, and you are permitted to give that copy. As a general rule, we recommend extreme caution in disclosing personal information to anyone outside of the municipality. There are a lot of risks here. Your obligation is to keep that information confidential unless something specific applies. And if you have any doubt as to whether the specific exemption applies, we suggest you speak with your lawyer or speak with the Privacy Commissioner. Just make sure you're getting a review from it. One sort of unique question that comes up sometimes is whether someone can disclose information about a deceased individual. It seems sort of intuitive that the person is deceased, they have no more interest in their personal information. The Act actually disagrees. So the information normally cannot be disclosed unless the person has been dead for 25 years. There's a couple of exceptions to that. The first is if the individual asking for that personal information is the next of kin. If they are, and you as a municipality determine that the disclosure is not an unreasonable invasion of privacy of the deceased person, then you can make that disclosure. The second place that we see this is related to estate administration. If the executor or administrator of the estate is inquiring about the personal information and the request relates to the administration of the estate, the information can be disclosed. So there's just a few comments there on an example that came out of the Privacy Commissioner's office a couple of years ago. A local health authority received a request from a deceased woman's son for all of the records that related to her care while she had been with this health authority. The family, it turned out, was not very happy with the care she had received, and she ultimately died while in this hospital. So the son made the request for this personal information, and the health region denied it, said that it was not in, it would have been an unreasonable invasion of the woman's privacy if that information was released to her son. The commissioner actually disagreed with that and said that his request from the hospital to get information which could potentially support a lawsuit against the local authority was part of administration of the estate, and then required that they release the documents on that finding. So what we can take from this is that the estate administration criteria will be construed quite broadly. So typically what we're recommending is if you are pardon me, receiving a request from a next of kin who is also the administrator or executor of the estate, typically you should just disclose the information to them. Probably the reason for the request relates to the estate administration. Certainly you're justified in making inquiries as to how those two fit together, but typically the next of kin / estate administrator will be entitled to that information. One question that we get quite a bit is whether individuals are allowed to look at the files that contain their own personal information. And our standard answer to that is yes. If someone is requesting information that relates to themselves, that is personal information to them, they will typically be entitled to look at that information. Now that said, there's some procedure that's got to be followed and some exemptions to that general rule. So in terms of procedure, there's a formal application form that needs to be provided, and then there's an identity requirement as well. In some cases, it may not be necessary to receive formal proof of the identity of the applicant, but out of an abundance of caution, we are recommending that that take place in the majority of cases. The reason for this, your formal application is a written application form, and a lot of times that might just be left on a desk, it might be submitted by mail, you might not receive it from the person who's making the request, even if that person is known to you personally. So there is some concern that someone could make a request pretending to be another individual as a means of getting access to that personal information. So you should require identification from the individual who the application is being made in relation to. We recommend a driver's license, birth certificate, passport, anything that can be used to conclusively confirm that that person is who they say they are. Now there are a couple of exceptions to this. So you're not universally entitled to information about yourself. The first of those relates to sort of the job interview scenario. The municipality can refuse to provide records that are evaluative or opinion material, which is compiled solely for determining eligibility for employment or for awarding contracts. So if you're doing a job interview from somebody, you make some notes about why they're a good candidate or not, you are not required to disclose that information to them later. You can do so if you make that decision, but you're not required. And so obviously there's some judgment call to be made there, particularly if you're talking about people who were not the successful candidate. They may be angry with you. They may be seeking this information for a less than good faith purpose, and so you may want to exercise your discretion to retain that document in your confidence in those scenarios. The other exemption, which we'll call it, is related to other third-party information. So if your personal record contains information which is personal to another person, that third-party information cannot be disclosed. So that information may have to be severed if it's possible, or in some cases, access to the document should be denied. This typically comes up in the sort of workplace incident harassment report type scenario. Often, say for instance, the victim will make a request for information for the harassment report. You may have to redact personal information from the perpetrator in that scenario before you disclose the document. Now, it's only personal information that would be redacted from that. The conclusions or recommendations that are coming out of a report are typically disclosable, but the personal information of a third party would have to be redacted. Now, that exception, pardon me, that exception is a mandatory exception. So you cannot exercise your discretion to disclose third-party information. Now, the final point on personal information end of things is just the right of correction. So once the individual has accessed the record, if they believe there is an inaccuracy in it, they are entitled to submit a request for correction. Typically, if there's no good reason to deny the correction, if you have no reason to believe that it's not correct, you would make the correction. So this would be in sort of the incorrect birth date, change of address scenario, right? But alternatively, if there's good reason for it, for not making the correction, you're also entitled just to make a notation on the record that a request for a revision was made. So if we go back to that example of a harassment investigation report, it's quite likely that the person accessing that report doesn't necessarily accord with your conclusions. They may request a revision of that, and you would just make a notation on the file that a request for revision was made but not followed through. So that wraps up our personal information end of things. So now we'll kind of go over into the other half of the Act, which is the access to information. So this portion of the Act is basically the opposite of the personal information end of things. The personal information end of things, as we've seen, says that information should always be kept confidential unless there's an exemption that says that you can disclose it. On the freedom of information thing, the presumption is always that you will disclose the information unless there is an exemption that applies to you to keep that information private. I will say that most of the problems that we've seen from municipalities relate to this half of the Act, to a request for information that is not responded to properly. These often stem from a lack of understanding about the requirements and procedures. The Act is quite technical, and there's a lot of little things that you need to do or not do to make sure you're in compliance. But I think they also relate to a lack of resources for response. There are a huge number of requirements under this Act. People are not well equipped to deal with them, and sometimes it is just impossible to meet the timelines that they set out in here. So I think there's a number of concerns arising out of compliance with this legislation, but hopefully we'll give you some guidance in that today. So under the Local Authority Freedom of Information Act, the head of the local authority is responsible for most of the decisions. By default, the head of a municipality is the mayor or the reeve. Now, in most cases, the mayor or the reeve is not going to be dealing with the day-to-day management of these requests. That typically will fall to an administrator or clerk. One of the problems that we're seeing is that often this is not done in a formal manner. It just sort of falls to the administrator to take care of these on a day-to-day basis. So it is important to note that the head can delegate his or her authority, but they need to do so formally. The commissioner, if it gets to the stage where you're interacting with that office, typically does not like to deal with an administrator who has not been properly appointed. So there is some concern there that it could come back to bite you if you don't make the proper delegation. But Section 50 of the Act provides you can delegate. You can delegate any authorities of the head under the Act, and you can also put in any limitations or restrictions that you need on that authority. So one of the questions that came up in the previous session of this, this presentation was whether that can be done as a matter of policy, and it can. There's sort of two options that we're seeing on this. One is to either, each time there's a new administrator in place, to do a letter that specifically delegates authority to that person, and that typically stays in force until it's revoked or until that person no longer occupies their position. The other option is to do it as a matter of policy, and that seems to be quite effective as well. So a person who receives that delegation is referred to as a privacy officer, and they become responsible for dealing with freedom of information requests within the bounds of their authority. So as I mentioned, the presumption under LAFOIP is for access. Unlike the personal information aspect of things, on this end, you are going to be trying to keep matters confidential that the Act would tell you you have to disclose, and that's where the tension typically comes in here. The Act is based on an exemption system. So if there is no exemption that applies to whatever record it is you're talking about, it has to be disclosed. The Commissioner, if they're asked to review a document, which we'll talk about in a little while, typically looks more favorable on you if you've done what you can to disclose records rather than trying to keep everything private. So the first concern that we have under the freedom of information side of things is for record storage and retrieval. As we mentioned before, record under this Act is very, very broad. And so you are required as a municipality to have a record of storage and retrieval for all of those documents. And it's a big task. That said, many of the freedom of information requests that we're seeing are similarly broad. For instance, someone might request all of the correspondence between the municipality and a third party between the dates of January 1st, 2009 and December 31st, 2014. There's no restriction on what they can request. So that some of them are very, very broad. And in order to respond to those very, very broad requests, you need to have a system that allows you to retrieve your documents easily. A municipality, if you get into the point of asking for fees for response to a disclosure request, you're only entitled to charge them for searching in well-organized records. So if your files are a mess, that's on you. And you've got to get your files into reasonable order before you can start charging an applicant to search through those files. In addition, a well-organized file system is helpful if you get to the review stage because the Commissioner is going to want details of what you searched, how you searched it, and how you can be sure that that's comprehensive. So getting sort of into the meat of the freedom of information side of things, these will come up when you get a request for information. And a request for information can be submitted by anyone. Any individual has the right to submit a request for information, and that request has to be adjudicated by the municipality. Organizations are not entitled to submit requests, and for this reason, a lot of times you will get an individual application that is very clearly submitted on behalf of an organization. One of the comments in our previous session was that it's only people who are angry or the media who will submit requests, which is probably not far off from the truth. One other thing, I mean, even in our office, in our non-municipal work, we will occasionally submit these documents on behalf of our clients. So you, as a municipality, will probably have no trouble figuring out who the organization is that is actually behind the request. But all requests will be made in an individual name, and they cannot be adjudicated differently because of who you think is behind it. So the request is supposed to be in the prescribed form. Some of you have probably seen emails that come in that say, I want this information, forms that aren't correct, all sorts of documentation that doesn't quite comply with the form that's supposed to be submitted. The Commissioner has told us that that is not a factor for you to take into account. If the intent of the request is clear, it should be adjudicated just like you had received a proper form. The request must be accompanied by the application fee of $20. The application fee covers the first bit of searching for the applicant, but not any actual disclosure, and we'll deal with those fees in a little bit. The applicant is required to identify the records that he or she is requesting, and they have to do so in a way that lets you, as someone who is sufficiently familiar with the documents, to identify them. If it is not clear from the initial request what the applicant is actually seeking, you're entitled to go back to them and request better details, and you're not required to provide any other response until you get that narrowed request from the applicant. This is another reason to have well-organized files, because if you know what they're looking for, you can usually narrow it down a little bit. This is one of the sort of key points I'd like you to take out of today's session. Under the Health Information Protection and Privacy Act, there's an explicit duty to assist an applicant. There's nothing like that in the Local Authority Freedom of Information Act. And so if you were just to read the straight text of the Act, you would probably assume there's no duty, as most people would. The Commissioner takes a very different view on that and takes the view that there is an implied duty on a local authority to assist an applicant with his or her request. In order to meet that duty, you have to respond to all requests openly, accurately, and completely. The Commissioner takes the position that this is consistent with the principles of the Act, with the intent of the Act to provide public disclosure of as much information as possible. So we're suggesting that in order to make sure you're consistently meeting this duty, that you're in contact with your applicants. For instance, if you get a request that is overly broad or not clear, give the person a call. Find out what they're actually looking for and then help them to narrow their request to really get the information that they're seeking. Communication is key here. If you fail to respond to an applicant, it's quite likely that you've also failed in your duty to assist, and the Commissioner will not be happy. So one of the first things that you'll want to consider on getting an application is whether you're actually the proper local authority to be dealing with it. In some cases, people will submit their request to the wrong authority, and you have the right to transfer that document out. This is all covered off at Section 11 of the Act, but basically what the test is whether another local authority has a greater interest in the record. And the interesting thing about this is another local authority can have a greater interest in the record even if you have a copy of it. The test is just whether the other local authority made the record or caused it to be requisitioned, or whether they were first to obtain a copy. So for instance, maybe a neighboring RM requisitioned a report on the condition of roads in the area, gave you a courtesy copy of it. If you receive a request for information requiring disclosure of that document, you would be justified in sending that over to the original municipality because they are the ones who have a greater interest in that record. But if you're going to do this, you have to do it within 15 days of receiving the request, and you have to notify the applicant. So it doesn't completely relieve any obligations under the Act, but it's definitely a lot less work and a lot less risky than dealing with the application itself. Now, if you're on the other end of it, if you receive a transferred request, basically your obligations under the Act are the same as they would be if you just received it fresh. You've still got to make the right responses, deal with the request appropriately, and the timelines just start from the day you receive it from the other authority. So Section 7 is the section that sets out all the required responses for receipt of an information request. If you read only one section in the Act, read this section, because this is the one where people typically fail to meet their obligations. Now, unless an extension of time is requested, and we'll talk about that in a few, a Section 7 response has to be delivered within 30 days of receipt of the proposal. This is consistently an issue, and it's not surprising. Given the volume of some of these requests, sometimes it's just not feasible to get a response out in 30 days, but the Act and the Commissioner tell us that that's what we need to do. Now, the options for responding under Section 7 are listed there. There are only 4 of them. These are your only options. You do not have the option to make any response which does not fall within one of those 4 items. So either you can grant access to the document or part of it. You can require payment of fees if that's appropriate. If the record is already published or is going to be published within 90 days, you can direct the applicant to that publication. So for instance, if it's on your website, direct them to the website. Third, if the access is refused, you must state the reasons for the refusal and the specific sections that you're relying on in the Act. And fourth, if the document doesn't exist, you can deny access on that basis. But just keep in mind, those are your only 4 options. In addition to one of those 4 items, your Section 7 response must provide that the applicant can request a review of the decision by the Commissioner within 1 year after notice is given. The Commissioner is very strict on this requirement. If your document that you send to the applicant does not have this line in it, they will review your documentation at that stage. And you sort of get red flagged at that point. If you've already issued a non-compliant response, the Commissioner's probably not too happy with you, and they're going to look at everything you do in a little bit more detail than they might otherwise. Failure to issue a compliant Section 7 response, which is what we call them, will give rise to an expedited review, which is what the Commissioner calls it. So this basically means they look at the request, they request some submissions, and they will typically require the municipality to issue a new Section 7 response that is compliant. So you need to state your sections if you're denying access, you need to have that line in there about review, and that usually concludes the expedited response. But you're also probably flagged. And one of the things that I've noticed The commissioner is actually digging up work for itself and asking people who have already been subject to a expedited review whether they want a full review. So for instance, if you issue a response that doesn't have this line in it, the applicant is not happy and they go to the commissioner. The commissioner says your Section 7 response isn't compliant, I'm starting an expedited review. At the conclusion of the expedited review, you issue a new Section 7 response. It has that line in it and it says, I rely on Section 16 A, B, and C to deny access to this record. It is very likely that the commissioner will get in touch with the applicant and ask them whether they are satisfied with your new response. And if not, they will start a full review at that stage. And we can talk a little bit about what the full review entails as we get a little bit further into this. But just be aware your Section 7 response has to be perfect at this stage if you can manage it. So the extension of time. If you receive a document request and you're not able to comply within your 30 days that you're given under Section 7, in some very limited circumstances, you can apply for an extension of time. And there are only 3 circumstances where you can apply for that exception. First, if the record request is very large and you need to do a large search and response. Second, if there are a large number of requests, some applicants will separate their documentation out and give you 10 requests for 10 documents. And third, if you're required to engage in consultation or third-party notices. If none of those apply to you, you cannot request an extension of time. The lack of funds, the lack of staff is not an excuse. If you are going to invoke this section, if you do fall under one of those 3 criteria, you need to notify the applicant prior to the extension, and you need to still issue your Section 7 response, but now within the 60 days. The requirements for the Section 7 response do not change. So the actual search of the records, assuming you've got a response, or pardon me, you've got a request, you believe you might have responsive records, you're undertaking a search. So you must be very careful to make sure your request is thorough. This is one of the areas where municipalities are getting in trouble. They're searching either just the electronic documents or just the paper files, or in some way limiting their search in a manner that's not justified by the nature of the request. The other thing to keep in mind here is to be sure to keep clear notes. If you get to a review, the commissioner is going to ask you all of the questions that are on the slide right now about making sure that your search was thorough and adequate. And if you can't provide any submissions on that, it's very likely that the commissioner will obligate you to redo your search to find more responsive records. So it's imperative to keep a record of what you're doing and how that's in satisfaction of your obligations under the Act. Now, if you've made the decision to grant access, this means that you've determined that there's no exemptions that apply to your record. And this just goes back to that principle of providing as much disclosure as possible. If an exemption is applicable to only part of the record, you are obligated to sever the exempt portion if you can. One interesting, oh, sorry, I'm a slide behind. One little interesting tidbit that's come up here, the commissioner has decided that to and from lines and potentially the subject line in an email are not exempt and that they are disclosable, even if you redact the entire body of the email. Now, it would seem to me, if I was reviewing that document as a head of a local authority, that it's not even worth disclosing that information because there's so little of practical value there. The commissioner, incidentally, disagrees. So you always have to keep in mind the principle of disclosing as much information as possible. And even if it's just who received an email on a particular date, that information is disclosable and should be provided to the applicant. Now, just a couple notes on exemptions. There's 2 types of exemptions under the Act. The first are mandatory and the second are discretionary. For a mandatory exemption, you have no discretion to determine whether to release the record or not. If the exemption applies, you don't release the record. But a number of the exemptions are discretionary exemptions, and that means that you, as a local authority, get to determine whether you should disclose the record, notwithstanding the existence of the exemption. You are required to use good faith in making that decision. So is it in the public interest that the decision or that the document be released? Is anyone going to be unduly harmed or benefited by releasing this document? Are there any justifiable public policy grounds for not releasing this document? In some cases, it is recommended that you release a document notwithstanding a discretionary exemption. So fees. If you're going to grant access to a record, you can typically recover some of your fees for doing so. Now, typically, if the document is 1 or 2 pages and easy to find, most municipalities are not claiming fees. They're just providing a copy of the record with their Section 7 response. But you are entitled to and should, in many cases, receive some compensation for the resources that you're expending in fulfilling these requests. So the current fees are, there's a huge list of them actually in the regulations, but the most common ones are $15 for each half hour or portion thereof of searching, and 25 cents a page for photocopying. So this is anything that's beyond 1 hour of searching. That will be complimentary included with the application fee. But if you're spending any more time than that, you are entitled to claim that back from the applicant. If the fees are going to exceed $50, you can issue an estimate and you can get half of this paid up front. There's some advantages to do that, obviously. First of all, it ensures you're going to get paid at least half. And in some cases, if the fees are excessive, oh, sorry, excessive is the wrong word. If the fees are substantial but fair, it can dissuade an applicant from proceeding with the request. And I mean, that just means less work for you. The disadvantage is that you actually bind yourself to this estimate. So if you estimate the fees are going to be $100, that is the maximum you can charge the applicant, even if it turns out that it's a lot more work than you anticipated. So your estimates, jumping to the third bullet, have to be fair, reasonable, and at a level that does not prevent a reasonable person from exercising their rights. So your fee estimate should not be excessive. It should not be meant as a deterrent from someone exercising their rights under the Act. That said, if there's a very large and extensive request, you may have a very large estimate and it may be justified. In reviewing these types of estimates, there are 5 things that the Commissioner is going to want to see. They're going to want to break down between time spent searching electronic records and searching other records. They're going to want a breakdown of time spent preparing electronic records and preparing other records, and then they're going to want an estimate as to your costs of reproduction. And just on the preparing records issue, that does not include any of your time that's spent actually reproducing the documentation. That's included in your photocopy fee. The production of the record just includes compiling it and, if necessary, severing portions that are not to be disclosed. So if you're already charging the 25 cents per page for photocopying, you don't get to charge the time that you're actually standing at the copier making those copies. The fee estimate also has to include the number of employees that are going to be doing the searching. If there's going to be more than 1 employee, you have to have an explanation as to why. Doesn't mean you can't have more than 1 employee, just that you need to have a good reason for doing so. And a lot of times it's just related to staff time. If you've got a part-time staff member, they are probably not in the office long enough to do the search themselves. And I think that's a justifiable explanation. In some cases, the applicant can request a waiver of the fees. And there's 2 areas where this typically comes up. First is for personal information. And the second is for information which should be disclosed in the public interest, but which would cause a financial hardship for the applicant. Now, you are not mandated to accept these waiver applications. You're just required to consider them. So in many cases, you're probably not going to waive the fees, but you are required to use good faith to determine whether it's appropriate in that circumstance. Now, if you've made the decision not to disclose your records, first recall that it cannot be refused except if there's a specific exemption in the Act. In addition, if you don't provide a response under Section 7, you'll be deemed to have refused access to the record. Now, this is a problem for you because Section 7 says you have to set out the specific reasons why you're not providing access, and you need to set out the specific sections of the Act as to why you're not providing access. So if you don't issue a response, you haven't done those things. And the Commissioner will typically mean then that you're not relying on any exemptions to refuse disclosure, which typically means that your record has to be released. So failure to provide a response does have some very serious consequences. And unless you want that document out floating around, you should probably try to get your response in. Now, just an issue about the exemptions. When you issue your Section 7 response, you are supposed to set out every reason that you have for not disclosing the document, and that has to include specific sections under the Act. If you do not set those out in your Section 7 response, the Commissioner typically will not let you raise those later, especially if it's a discretionary exemption. So if you say in your Section 7 response, we rely on Sections 16A and B as reasons for not releasing this document, when you get to the review stage, you can't say we rely on Sections 16A, B, and C. The Commissioner will not consider your exemption under 16C. The only exception to that is if you're talking about a mandatory exemption. So for instance, third-party information is a mandatory exemption. It cannot be released unless an exemption applies. And the Commissioner will still look at those if you forget to put them in your Section 7 response. Our recommendation here is if you are not accustomed to dealing with these, if you're not seeing a large number of information requests and don't have the appropriate training, if you're going to deny access, speak with your lawyer, because it will probably come back to bite you. So you've heard me talk a fair bit about exemptions, and you're probably wondering what on earth they are. So exemptions to Freedom of Information requests are set out in Part 3 of the Act. There is a huge number of exemptions, and it's really too numerous for me to even go over today to let you know what you need to be looking for. But they will be very narrowly construed, and the Commissioner, on the basis that more disclosure is better, typically will not look at an exemption unless it applies directly to the facts. But some of the major exemptions, we'll start off with documents which are obtained in confidence from another party, particularly from another government agency. So that might be another local authority, it might be provincial, it might be federal, but if you're receiving documentation from a government agency on the basis that it's confidential, it typically will not be disclosable. If there are documents, the disclosure of which might interfere with a law enforcement operation, you would be justified in holding those back as well. This is one of the biggest ones, documents that are internal to the municipality that have not and will not be made public. So this can include just about anything. For instance, draft documents, in particular bylaws, in-camera meeting records, policy options, advice and analysis that's developed for or by the municipality, documents regarding contractual or other negotiations, financial, commercial, scientific, or technical information, legal advice, and testing or auditing procedures if the disclosure might interfere with carrying out that testing or auditing. And finally, there's sort of a catch-all for documents which may result in an undue loss or benefit to another person or threaten the health or safety of any person. So most of these are discretionary, which means that if you believe it applies, you still have the discretion to release the document if you feel it's in the public interest to do so. Third-party information, however, is a mandatory exemption. If the third party doesn't provide you with consent and an exemption doesn't apply, the information has to be released, denied. The third-party exemption will apply if the record contains trade secrets, financial, commercial, technical, scientific information supplied in confidence to the local authority, statement of financial account relating to a third party with respect to provision of routine services from your municipality. Can't get your neighbor's water bill. Information, the disclosure of which could reasonably be expected to result in a financial loss or gain to prejudice the competitive position of or interfere with contractual or other negotiations. So that sort of catch-all tends to come up a lot in these exemptions. The Commissioner will look on it very strictly. We had one case that went to review where the Commissioner said it wasn't enough to say disclosure of a contract might interfere with contractual negotiations. They wanted specifics as to what contractual negotiations would be interfered with if that information was released. So it would have to be specifics as to time, as to a specific contract or project that was anticipated. Just picking out these exemptions is not going to be enough for the Commissioner. So third-party access in terms of procedure. Under the Act, if you get a request for information and intend to give access to it, you are required to notify the third party. So an example of this might be a contract that you have for fuel services. A fuel tender went out, you've awarded the contract, and someone has sought access to that. If you intend to give access to that, you are required to notify the party that holds that contract. They have the time to consider that, to provide you with any submissions, and then ultimately the decision is still with the head as to whether to release that information or to withhold it. In practice, we're recommending that a third party receive notice anytime you have a third party involved in the documentation that has been requested. And there are a couple reasons for this. First, this is the first thing the commissioner is going to ask about. And second, you need to ask them for consent to release the information. Even if you don't really want to consent to the release of the information, the commissioner will ask whether you've asked the third party for consent. And if you haven't, they will. So in the interest of looking like you've covered off your duties and facilitating the process as much as possible, it's typically recommended that you give the third party notice of the application as soon as you've received it and identified that the third party may have an interest in the document. Just a note here at the very bottom, and this is sort of going back to what I talked about earlier about the name of the applicant. The commissioner recommends that the name not be released to the third party. That you advise the third party simply that an application has been made and that you are requesting submissions as to whether the document should be disclosed. Their position for that recommendation is that the third party should not be making their decision as to disclosure based on who's trying to get it. And so sort of going back to the fuel tender contract example, it's very likely a competitor of the successful party that's trying to get a copy of the contract. That shouldn't influence the decision as to whether to disclose the document or not. So confidentiality. As you'll have seen through the slides, a number of the exemptions relate to documents that are provided to the local authority by another party, either implicitly or explicitly in confidence. Pardon me, there's a few factors that the commissioner will look at to determine whether something was actually supplied in confidence. And simply marking confidential on the top of every page if the document is not really confidential is not going to be enough. So some of the things that they're going to look at is whether there is a mark on there that indicates it's confidential, whether it was delivered to the municipality in confidence, sealed envelopes, password protected, those sorts of things, and whether the municipality provided any assurances that it would be confidential, whether it was a motion, a term in a contract, something like that. So commissioner's review. So this is based on the assumption that you've gone through this whole process, you've issued a decision to the applicant, you've maybe made some disclosure, maybe not. You maybe have involved the third party, maybe not, depending on the particular circumstances of the review that you received. That next level is to go to the commissioner for review. And so usually this is in a case where an applicant is not satisfied with the disclosure that they've received. In some cases, it can also relate to a fee estimate, and if a third party has been involved, they can also bring an application for review if they're not satisfied with the decision. The important thing to note at the review stage is the commissioner doesn't really have any authority at all. The commissioner can make inquiries, will issue a report, it'll have recommendations in it, but you are not bound by the recommendations. It is entirely a recommendation, it is not an order, and the commissioner does not have any authority. The commissioner can deny an application for review if they determine that it's frivolous or vexatious or trivial. I don't think this happens a lot in practice. I think the commissioner typically takes these matters very seriously. If they think there's any grounds at all for review, they will proceed with the review. So once the review has been undertaken, the commissioner will seek input from both parties. Normally this involves the form of a written submission. The written submission is typically shared with the other party. A copy of the record will almost always be required, and if you'll recall, that is one of the exemptions to personal information, so you can disclose that record to the commissioner. The commissioner will not share that record with the applicant at any point in the proceeding. Once the review is completed, the commissioner will issue a report, and as I say, all it has is recommendations. Typically, the recommendations will be to release a document or determine whether a particular exemption was validly raised. And once they've received the report, the head of the local authority has to issue a response within 30 days. They can decide to follow the recommendations or not, whatever they decide is best at that point. Both the commissioner and the applicant have to be notified of that decision. The final step in the review process is an appeal to the court. Now, this is very rare. I'm not sure if anyone's been following the news, but there actually is a case right now which is pending based on an application for review. But I think the former commissioner just commented there's been 2 or 3 in the past 10 years. So it's very rare that things are going to court. I think it may become increasingly common, but at least to date, we're not seeing a lot of it. This application can be brought by any applicant or by a third party if they're not satisfied with the response of the head to the report of the commissioner. So this will typically come up if the head has decided not to follow the recommendations in the report. The court has very broad powers, and unlike the commissioner, they can order you to disclose the document. They can also order you to pay costs if they find that your behavior or your position was not appropriate. They can also order the applicant to pay your costs if they find that their request was unreasonable. So the court has very, very broad powers and can make any decision it considers appropriate. There's also a few provisions in the Act for criminal prosecution. We haven't seen much of that so far in Saskatchewan. If you review the reports of the commissioner, I think a recommendation to prosecute is becoming a lot more common than it used to be. But so far there hasn't really been any action on that. So that concludes the formal portion of today's presentation. I guess I'll just invite anyone interested to come up to the microphone with questions.
I guess after that, yeah, it's what questions do you ask? There's privacy statement questions like, what is the difference between use and disclosure, for one?
Sure. Okay, well, use just means that you're using it internally. It means that the municipality that collected the information is using that information. And your rights of use are not unlimited. You can use information for the purpose it was collected or for a purpose that is subject to an exemption. Disclosure means giving the information to another person or another entity. And disclosure must be done cautiously and only in accordance with the specific exemptions that we went over.
I can leave these here for you. I guess the next one is what is considered consent to release information and when do I need it?
All right. Section 11 of the regulations actually directly addresses this issue. Consent should always be in writing if at all possible. If it is not reasonably practicable to get the information or the consent in writing, a verbal consent can suffice. From a legal and liability perspective, our recommendation is that you always get your consents in writing. Consent may be general or it may be in relation to a specific request. So you may get more general consents from the people that work in your office, your counselors or something like that to the disclosure of information. Or you may be contacting third parties with respect to consent for a specific information request that you've received. Consent is needed anytime you're disclosing personal information to a third party or anytime you're disclosing third-party information to a third party. Okay, I'll just go through the list here, it's easier. The next question on the list of suggested questions, how long should I keep the personal information I collect? So there was a decision of the Privacy Commissioner a couple years back that said personal information should be kept for a minimum of 1 year after the decision is made. This is because the Act provides for that 12-month review period. Now, we have a couple differing suggestions on that. From a liability perspective, you can be sued on something anytime up to 2 years after it happens. So our base minimum is keep it for 2 years, not just for privacy perspective, but for any potential claim that's going to be brought against you. In addition, it should be kept for as long as it's being used by the municipality, and thereafter we would hope you would have a record retention and destruction policy in place that would tell you how long to keep it, but most places were ballparking about 7 years. Sure.
If I may add, one of them that I always wonder about, and I guess from before I retired a previous life, but with a sick note, how many, when one of the employees calls in sick, who do they bring the sick note to? Who's qualified to read it and interpret it? And do you have the right to?
It's a very interesting question. One of the major issues that's come up in this area is faxing sick notes in. And the commissioner has come out and said it is completely inappropriate to fax sick notes to an employer, basically because you have no control over the information. If the fax number is off by one number, you're giving it to who knows who, and it's typically sitting out on a public fax until somebody comes across it and takes it. So the delivery of sick notes is sort of its own issue that's getting a lot of discussion right now. But in general, unless the employee is comfortable doing so, they should not be encouraged to fax their sick note in. If they're delivering a sick note, either email or personal delivery or mail, that should typically be opened by the person who has responsibility for that person's employment, whether it's a direct supervisor or someone up the chain, depending on the employee's position. The immediate supervisor would typically be the person who would receive that information and relay it upward on a exclusive need-to-know basis. That information should not be shared with anyone who is not above that person on the chain of things, and not with anybody who doesn't have a need to know that information. The other issue that comes up on this sometimes is how much information do you give to others in the workplace or to someone who might be calling in for that person. And the standard practice that's evolving is simply to advise that that person is out of the office, not even to advise that it's necessarily an illness. And that communication should be consistent across other employees, other departments, and anybody from the public who might have a need to know that as well.
And for as far as interpretation then, if you got a doctor's note that says you have something that long, and I know if you're working in a union atmosphere, in an organized with your town, who should read it, or should that be, because I know it used to be an issue with the Crowns. There was a qualified nurse that read that note, so as a manager, I got the note, but it was in a sealed envelope. I forwarded it to the nurse that was on staff in Regina. We didn't even open it.
The question was about who should actually be opening that note, and Barry made some reference to his former position with the Crown Corporation, where the information was actually relayed to a nurse who was qualified to review the medical information. Now, most municipalities certainly don't have that capacity on staff, right? And so most of the time, it's just going to be that person's immediate supervisor who's reviewing that documentation. It's not ideal in terms of spreading the health information around, but it's about all we have. And so it is typically appropriate for the immediate supervisor to read it and to make an assessment of whether the content is reasonable or not.
Okay, thank you.
All right, one other question that was on my list of things to raise if no one had real questions was, oh, sorry, go ahead.
I'm from the town of Choiceland. I'm the administrator. I'm confused about consent. Wouldn't the person faxing his sick note in have consented to sending that information over the fax?
It's a very good question, and I think it depends on where the fax is originating from. A lot of times it's coming directly from the doctor's office to the employer, and that's where they're saying it's not appropriate because that person hasn't explicitly consented to it. But I think if your employee from his or her own home or from a business location sends that documentation in, subject to them being aware of where the fax machine is located and who might have access to it, I think there's a decent argument for implied consent. It's still not quite as explicit as I'd like to see it, but there's an argument to be made there.
And another consent issue is like information, other companies seeking tax information, like lawyers seeking tax information from municipalities for the sale of real estate or whatever. Are the people consenting to releasing the information through the lawyer, or is this no longer a good practice to issue?
You're still just fine to release that information to the lawyers. The commissioner actually did a report on something very similar a while back. It was a gentleman who made an application to have the names, addresses, phone numbers, legal land description of everybody who was within a particular development to find out I'm not sure who was paying more taxes or something like that. And the commissioner actually determined because all of that information was already publicly available, it wasn't inappropriate to release it. So because as a municipality, you have certain obligations with respect to issuing a tax certificate on request, preparing the assessment roll and having that available for public inspection. You're not offside to be giving that information on a request. Thank you.
I'm not altogether sure the discussion has to do with council chambers itself. But one of the things that concerns me as a new person on council, relatively new, is disclosure of information when it comes to dealing with certain things that are happening in your community, particular to a piece of property. And normally our policy is that we would use the land description or something, but we all know who we're talking about. And so at what line is that, because it's in a public chamber forum, it's going to go in minutes or something like that, becoming disclosure, personal information, or is it? Or are we just sort of hedging because this law is sort of ambiguous?
That's a very good question. Actually, the same question was raised in our last session, and we don't have a clear answer for you. I think it's one of those cases where the disclosure of the name issue is a tricky one. To the extent that the registered owner matches the person that you're speaking about in council, I don't think you have an issue. I think it goes back to the previous question. If it's available on information services, it's public information and you can disclose it. The only concern I would have would be if you had, say, an unregistered lessee who was dealing with the property, hasn't registered their interest on title, and is potentially, the nature of their interest in the property is potentially being disclosed in public chambers. But I would suspect that your obligation as a municipality to make decisions in an open forum would override that potential concern.
Yeah, and I'll be very specific with one I think that affects most of us, is the delinquent tax roll. So that we got, in our town we might have one. Ha ha, I wish. But yeah. But let's say there's significance, and it's been policy or told that we can't name Mrs. Jones and Mr. Jones and stuff. So council is looking at this, well, we really don't know all of this. How do we make informed decision? Or either we go in camera and do that, or like, what's the right way of doing it? Or is there a place we can find the right way?
I don't know that there is a right way. I think there's a number of policy options you could have which would conform with the Act and still meet your obligations in terms of transparency and open meetings without reviewing any specifics and taking some time to sit down and dig through the Act and see how it fits. I don't know offhand. I think that may be a discussion to have amongst yourselves and find a best practice as municipalities, or to have with your lawyer and find out what works for you.
What is the duty to collect the information? I get 60 to 70 emails a day, deal with them, they're gone. Is there a duty on us to keep some information that potentially could become a request down the line, or what are we supposed to do there?
Well, our first suggestion would be to have a record retention and destruction policy that hopefully would address that. It wouldn't necessarily matter what the content of your policy is, as long as it's consistent and fair and being applied across the board. There have been a few cases where the commissioner has looked at what they're calling transitory documents. So you've got some documentation, whether it's an email or whatever, that's used for a very interim purpose to make a decision and then is destroyed after that. The commissioner typically has not been too tough on those, provided that the destruction was not made subsequent to the information request being received. So if you're aware that there's an outstanding request for information on XYZ land development, you would take some extra care to preserve those documents. One of the other draft questions I've got here was what to do if there had been an accidental loss or disclosure of personal information, so privacy breach. Couple of suggestions in those circumstances. First, if it's appropriate, advise the individuals who've been affected. If you can list the people whose information has probably been disclosed. It's appropriate to contact them directly. If you're talking about a much broader breach, then it may be just more appropriate to notify the public in general, but not to communicate specifically with the individuals. Second, offer any possible assistance to protect or minimize the loss of damage, the loss or damage. So if that's, I know it's come up for a couple big corporations lately, providing some credit monitoring on the disclosure of financial data. That may or may not be feasible depending on your budgetary constraints and the nature or the extent of the disclosure, but anything you can do to minimize the concerns would be appropriate. Consider proactively advising the Office of the Privacy Commissioner. They are a very good resource and they can provide you with some assistance in terms of managing the breach. And then conduct an internal investigation. The scale can be commensurate with the scale of the breach, but just identify how the documentation went missing, what can be changed to prevent that from happening again. Any other questions? Thank you, everyone.
And I'd like to thank Candace. I guess we need to give them a round of applause because they do not charge us for this service. And in lieu, there's a donation to the Mike Badham Scholarship Fund.
Thank you.
Thank you very much.
That's basically what we said. Well, what we told them was we're not certain we can release it. So in the interests of not going blind, we will not tell you. However, if you go walking down the street and ask somebody, and
You might be
they
able
tell
to tell you. Yeah, I think you were completely appropriate there. I mean, the best response was you're protecting that information until otherwise. I think you could have said, if you want to make a formal request for it, we'll consider it. We'll have 30 days to sort out whether we're allowed to release it, but to just walk into the office or not.
this the deadline for the news launcher.
You're welcome. Hi.
Scott, you're thinking about this. Hey, gentleman brought up a question about this.
Yeah.
Is that something that was who's on this list?
Well, that's what we were just talking about. I think it's entirely appropriate.
I never confirmed if I
Okay.
if I had that question, I'll just say, I don't know.
Right.
Sometimes there's been counselors on this.
Well, it sounds like
My other question is, if somebody comes in and there's one issue on their list, I wouldn't have to give them like their pay stuff.
No.
It was just
Yeah, I mean, ideally, they should phrase their request as a specific document, right? Do they want a copy of the budget that shows that? Do they want a copy of the pay stub, which might have a personal agreement? I mean, I think if you got a copy for the pay stub or a request for the pay stub, you just redact out everything except the salary. Yeah.
Thank you.
You're welcome.
Okay.
But they're not on the right side of something.
That's not fair. So, they want us to. too, the worst thing to hold on, these businesses are so great, and here's the poor people that are, you know, they're busting their butt, they're doing everything, they're the ones that support more than any of them. And they're blocked right out. Last year they did, they even came for supper. And then stopped on the new board. I really don't want to go back. This is what just I'll miss that one. I had a flat tire. I'm sorry. Banquets at 6 o'clock and I couldn't make it back. I was
Everything went good again?
until 2:30 or 3 here.